Top Gun Maverick has been a huge commercial and critical success for Paramount Pictures. However, the heirs to the author of the article upon which the original film was based have sued Paramount, claiming that the copyright has reverted back to their ownership. So will Paramount win this legal dogfight? Hi, James Pacitti, entertainment attorney and production counsel in Los Angeles. In the federal lawsuit filed by the heirs of Ehud Yonay, the plaintiffs claim that the underlying rights to the hit film Top Gun Maverick, which the plaintiffs contend is a sequel to the original movie and is also derived from the article published in 1983 in California magazine titled Top Guns, have reverted back to their ownership. It's worth noting that the 1986 film did specifically credit Ehud Yonay for his story. According to the complaint, Yonay's heirs availed themselves of the right to recover the copyright by sending Paramount what is known as a statutory notice of termination and filing it with the Copyright Office as of January 24th, 2020. Now, there's no question that under U.S. copyright law, an author or their heirs or survivors can terminate a prior copyright transfer under certain circumstances and regain rights to the work. This means that even a transfer of rights that at the time was in perpetuity, in other words, forever, can be terminated with the rights reverting back to the author or the creator of the work. However, works created before termination can continue to be distributed. Under copyright law, a derivative work prepared under the authority of the prior grant before its termination may continue to be used, but that does not extend to any work prepared after the termination. So whether Paramount wins or not probably will come down to a determination of whether the sequel was completed before the notice of termination. The plaintiffs contend that the film wasn't completed until May 8th, 2021, some 15 months approximately after the notice of termination. Paramount will likely make two arguments. One, that the sequel is not derivative of the article, and many of the facts contained in it are in the public domain, which nobody owns. In addition, Paramount may argue that the film was completed before the notice of termination, and any work that may have been done afterwards in post-production or such was de minimis, and that it was not significant. And of course, the delay in its release was based upon COVID and the desire for a theatrical release as opposed to a release on streaming. Obviously, the stakes are very high because the plaintiffs are seeking to enjoin the distribution, stop the continued distribution of the film, and also are seeking monetary damages, which, based upon copyright infringement, which obviously would be enormous based on the box office numbers to date. Depending on the demands of the plaintiffs and the relative strength of the parties' positions, Paramount may ultimately decide to settle this lawsuit so Maverick can keep flying in theaters. If you have any questions or if you have a project you wish to discuss, don't hesitate to contact us.